Hi, I'm a staff attorney at the Child Care Law Center. If you are a family child care provider and rent your home in California, there are 5 things you must know. 1. Landlords cannot stop you from providing licensed child care in your home. If you have a small licensed child care facility, which is 6 children or less, or a large family child care, which is 12 children or less, landlords cannot stop you from providing care in your home, even if your lease says no businesses. California law recognizes a family child care as a residential use of property as opposed to business use. So your landlord cannot restrict you from providing care in your home. 2. Tenants must inform their landlord of their intent to run a family child care in their home. If tenants have a small family care, 6 or fewer children, or a large family care with 12 or less children, the landlord still need notice. However, if a provider would like to take care of 2 or more children in either situation, so that means 7 or 8 children, or 13 or 14 children, that's when tenants must get the written permission of a landlord. Providers can be licensed by the state to provide care for these additional 2 children. However, the landlord must give their written permission. 3. Landlords may not evict tenants for having a licensed child care in their home. Landlords may evict tenants for other things such as non-payment of rent or violating any other clause in the lease. Providers need to be careful to follow their lease agreement so they don't get evicted for other reasons. If a provider feels that the landlord is evicting them just because of their child care, they need to contact an attorney right away. 4. Landlords may not raise the rent, but may require a larger security deposit. Landlords have the ability to raise the rent for other legal reasons, but cannot raise the rent just because a tenant is providing licensed child care in their home. A landlord may, however, request a larger security deposit. Landlords may charge up to 2 months' rent for a security deposit when they find out that a tenant is running a family child care in their home. 5. Landlords cannot require a tenant to purchase liability insurance, but if a tenant already has an existing policy, may ask to be added to the policy. Since landlords cannot put restrictions on family child care homes, landlords cannot require tenants to purchase liability insurance. Liability insurance is not required by providers. However, providers do have to inform parents that they do not have liability insurance. The Child Care Law Center recommends that all providers get liability insurance just for their protection. If a tenant does have an existing liability policy and the landlord requests to be added, the tenant may do so only if the landlord requests in writing, adding the landlord to the policy will not cancel the policy, and the landlord agrees to pay any additional costs associated with adding them to the policy. Remember, as a tenant in California, you have certain rights, even if you have a family child care in your home. Know your rights, be protected, and if you have questions or concerns, please contact the Child Care Law Center.